Okay, today we'll talk about some disfavored First Amendment speakers. The two for today are the Reverend Fred Phelps, whose speech is repugnant to, I'm sure, 99% of Americans. And then we'll consider Dannie Martin, whose speech is not repugnant, but whose status is. And he's in one of those categories of citizens whose First Amendment rights are limited, categories like school students, people in the military, government employees, and prisoners. So Reverend Phelps' case was decided in 2010, I guess it was, by the Supreme Court. He runs the Westboro Baptist Church in Topeka, Kansas, and has been its only pastor for 52 years. Almost all of the members of this tiny congregation are his family, his children, his grandchildren, and his in-laws. And the church espouses a fundamentalist Christian faith. Among their beliefs is that God hates homosexuality and punishes America for its tolerance of homosexuality, particularly in the military. And the stunt that Reverend Phelps and his church do to draw attention to their point of view, their religious/political point of view, is to go around and picket at military funerals around the country, displaying their signs like those that Reverend Phelps has here. And in 2006, a Marine by the name of Matthew Snyder was killed in Iraq, and his body brought back for burial in Maryland. His father chose a Catholic church for the funeral ceremony and put obituary notices in the paper, which the Phelps group picked up on and decided to go picket at Matthew Snyder's funeral. So Phelps went with two of his daughters and some of their kids, to the funeral, where they displayed, on a public piece of land about 1,000 feet away from the funeral, they displayed their placards. And they had notified the police before they showed up that's what they would be doing, and they didn't exactly negotiate where they would be, but they chose this piece of public property, which was 1,000 feet or so away from the actual funeral. And the people at the funeral, the Marine's dad, knew that the picketers would be there. The dad actually didn't see the picketers. He knew that they were there, and he didn't see them until he watched the television news that night and saw what the picketers had done, and he was really upset by this cruel stunt that the church people had pulled at the funeral of his son. So he sued. He was really emotionally distressed about it. He sued Reverend Phelps and the church for money damages, and he sued on two theories that we'll encounter later in the course, two tort theories, that is, civil wrongs, theories by which people can recover damages. There are lots of torts in the world. Libel is a tort, for example. Assault is a tort. Negligence is a tort. When you rear end somebody going down 50 miles an hour down Hearst, and you rear end somebody, you have committed the tort of negligence, not acting as a reasonable person would in the circumstances. Well, the ones that Snyder sued Phelps for are the intentional infliction of emotional distress, which is a tort that doesn't exist everywhere, but does in California and most states, and grew up as a matter of common law incrementalism, grew up in the common law, and allows somebody who is injured by an intentional infliction of emotional distress to sue for damages, and that's what Snyder did. And the other tort that Snyder invoked is intrusion, which is a privacy tort that we'll consider later in the course. Just tuck this away for future reference. The tort of intentional infliction of emotional distress is one we'll come back to, because that's the theory that the Reverend Jerry Falwell used when he sued Hustler magazine for having published a caricature of Falwell. And intrusion is a privacy tort having to do with, the word sort of describes it, intruding into your zone of privacy. And it doesn't have to be intruding into your bedroom, but intruding into a place where you have a reasonable expectation of privacy. And Mr. Snyder's contention in the case against Phelps was that Phelps had intruded into the funeral in a way that would be highly offensive to a reasonable person, which is what somebody who sues for intrusion has to prove, that the intrusion would be highly offensive to a reasonable person. The case went to trial, and the jury awarded $2.9 million in compensatory damages to compensate Mr. Snyder for the injury that he suffered as a result of the picketers' activities, and also punitive damages, $2.1 million in punitive damages. Punitive or exemplary damages are money damages that can be awarded in a civil lawsuit that go beyond compensating the person who's injured to punish the wrongdoer. Sometimes called exemplary damages, to make an example of the wrongdoer. The idea is to deter the wrongdoer from ever doing anything like this again, and to deter people like the wrongdoer from even attempting to do this. And in the case of Snyder versus Phelps, Mr. Snyder won $2.1 million in punitive damages over and above the 2.9 compensatory damages for a grand total of $5 million against the little church in Topeka, Kansas. And the church appealed, and the case went to the Supreme Court. When the case was argued in the Supreme Court, that's the description of the suit. When the case was argued in the Supreme Court, the church people are courageous, principled. They picketed the Supreme Court during the argument with their signs up. They weren't trying to conceal what they did. So the court decides the case of Snyder versus Phelps with this ugly, hateful, offensive speech at issue. And the opinion was, surprisingly, written by the Chief Justice, John Roberts, himself a Catholic. And it's one of those rare instances in which his decision and the Supreme Court's decision was consistent with the principles that he espoused during his confirmation hearings back in 2005, in the sense that the decision was extremely narrow, not a broad brush. All speech is permitted, government can't interfere with speech. Very narrow, very fact-specific. To the extent that it's hard to say what the principle is that Snyder versus Phelps stands for, because it is so tied to the particular facts of the picketing case. The decision was nearly unanimous, which must have been pleasing to the Chief Justice, because he's in favor of having unanimity, especially, well, he thinks it's good for the court not to have a whole bunch of split decisions. The decision itself emphasized that that it turned largely, as the Chief Justice said, on whether the speech of the picketers was of, quote, public concern. If it is, it doesn't matter that the speech is wildly inappropriate or controversial or offensive. And the Chief Justice looked to the content of what the picketers' signs said and was able to conclude that the content was political, that it had to do with the moral conduct of the United States, that it had to do with the issue of homosexuality in the military, and it had to do with misconduct by Catholic priests. And all of those subjects are of legitimate public concern. That didn't quite end it. I mean, the Chief Justice said our decision is largely based on the fact that the speech was of public concern. The court recognized the doctrine that we first encountered in the Clark case, the camping on the mall case, that there can be time, place, and manner restrictions on speech. And at least in the funeral context, there's a question about whether this is the place where the speech can be, where the right of free speech can be exercised. The Chief Justice says the fact that this was a private funeral doesn't transform the speech into purely private concern speech. It's still about public issues. But the Chief Justice emphasized that the picketers stayed a good deal away from the funeral itself. They were not visible from the church. There was no disruption by the picketers of the funeral proceeding. They stood in a public place, which is, of course, a traditional public forum. Public squares, public sidewalks are places that are quintessentially the forum for speech. And that's where they were. They didn't intrude onto anybody's private land. But it was telling in the case that the father, Mr. Snyder, in fact objected to the content of the signs. He was asked at oral argument, what would you have objected if the signs had said, God bless America, or God bless our soldiers, or God bless veterans. And his lawyer said he wouldn't have had any objection to that at all. He objected to what the signs did say. So, in effect, the suit was content-based and not subject to a time, place, and manner analysis because it was aimed at the content or the viewpoint of political speech. And so both the plaintiff's theory of the case, that is Mr. Snyder's theory, why he's entitled to damages, and the court's analysis looked to the content of the speech, not the conduct of the picketers in being at the scene of a funeral. There's only one dissent in the case, and it was Joseph Alito. I think his dissent is somewhat revealing of his thinking. He was really morally offended by the content and the behavior as well of the picketers. He emphasized that Mr. Snyder was a purely private figure, wasn't a public official, wasn't a public figure in any way, hadn't sought the limelight, wasn't involved in any issues of any importance. He was just the father of a young man who had been killed in Iraq, and Alito was entirely sympathetic with him. Alito pointed out that the protesters could express their views in all sorts of alternative channels. This is an echo of the time, place, and manner analysis, the availability of alternative channels of communications. The protester, Alito said, could do books, they could have articles, they could do videos, petitions, speak in public, go on television, radio, the internet, whatever they wanted to do, but it doesn't follow, according to Alito, that they could intentionally inflict severe emotional injury on a private person by launching a vicious verbal attack that made no contribution to public debate. Well, that's a mouthful. I mean, clearly they did something intentionally. They must have known that it would be hurtful to the people who cared about the Marine, including, of course, his immediate family, and that they were entirely private people who didn't have this coming in any way. But then Alito tacks onto that, these were vicious verbal attacks that made no contribution to public debate. In other words, Alito is deciding that this speech is valueless, the speech is worthless, the speech shouldn't have to be heard, which is extremely dangerous to the freedom of speech and the press, because you've got a judge deciding what is valuable in the way of speech and what isn't. So, Right. We'll encounter fighting words Tuesday, I think it is, in the Chaplinsky case, which was a classic 1930s Jehovah's Witnesses case, that established the fighting words doctrine. And it has come to be understood, the fighting words doctrine, as a one-on-one situation where what you're saying, probably screaming in the face of the other, is very likely to provoke a physically violent response by the person you're dealing with. And the funeral context of what Phelps and his people did would not qualify as fighting words. I mean, all they did was hold up their signs. I see your point. On the other hand, that's in tension with the established First Amendment principle that the fact that speech will be offensive to an audience and upsetting to an audience is not a ground for suppressing the speech. We have to take the risk that some speech will be unsettling, stir people up. Maybe they want to throw things at the speaker, but that doesn't make it fighting words. Kelly. Well, I think we can assume that the court acknowledged the reality of the emotional distress. They don't deny that Mr. Snyder experienced emotional distress. In other words, they're not evaluating whether these torts were committed. Those torts are state law torts. They don't have anything to do with the First Amendment. But the fact that the court, the trial court, awarded damages, that's the government acting, awarded damages for pure speech, what the protesters had to say, implicates the First Amendment. The Supreme Court's decision is entirely First Amendment based, and the court assumes that the elements of these torts, intentional infliction of emotional distress, intrusion into a place of solitude, that would be highly offensive to a reasonable person, the court assumes that all of those elements were proved. But the First Amendment trumps all of that. Well, when Snyder sued, he had to have legal claims that would justify his damages. So he makes two claims: intrusion, intentional infliction of emotional distress. And the defense was, we didn't commit those torts. There's no showing, for example, that with intrusion that this was a place in which Snyder had a reasonable expectation of privacy. But the jury found that, in fact, both torts were committed. The other part of Phelps' defense was the First Amendment forbids government from imposing liability on the facts of this case, based on what we did. And when the case was in the Court of Appeals, the defendants, the Phelps people, gave up their contention that the torts weren't committed. I think that was tactically a really risky thing to do, because they had pretty good arguments. But they gave that up and said, our case is a pure First Amendment case, and that's the way it was presented to the Supreme Court. It's either the First Amendment protects these protesters, or it doesn't. Right? Was he gay? No, he was not gay. Why would it have been different? If the dead Marine had been gay, why would it be different?
I don't know. I was just thinking it wouldn't be a hate crime. But I don't know if
Yes, the court mentioned, not as a major factor, but thought it was irrelevant, that the signs did not single out Snyder, either the dead Marine or the father, at all. Didn't mention them, didn't single them out for hateful treatment. It was all their general stuff about God hates fags and so on. And that sort of softens the case. It would have been a good argument on the torts that they didn't intentionally inflict emotional distress on Snyder. They didn't intrude into his space. And it would have been a plausible argument to make on the torts. But in the First Amendment context, it didn't really matter whether they, as the court found, whether they singled him out or not.
What if it had just been Phelps using the context of the funeral to get attention, not trying to use it? What if his friend had just said long distance injury or something, considered like nonsense speech just to get attention and not for like a political or religious view?
Yeah, knowing that this would get some attention, we're going to be in a place where there's going to be people, and if we put out a press release that we're going to be picketing there, maybe the television people will come and we'll get some coverage out of it. Well, look at what the court's reasoning was in Snyder versus Phelps. Would that have made a difference? Yeah, I mean, if the decision turns largely on whether the speech is of public concern, long hits for Jesus is nonsense, right? Yeah.